Good evening. I think this is a very niche area of practice, and only the actual practitioners of insolvency and those who are intending to take up the course will come. So instead of waiting for more people, I thought that we should respect our speakers and start at least not on time, a little beyond that. So
the NCLT and the NCLAT constituted at the earliest. By virtue of that order, we were given the NCLT and NCLAT, which was constituted on 1/6/2016 as a matter of background. Constitution of the NCLAT and its jurisdiction. So the NCLAT is constituted under section 410 of the Companies Act. It is competent to hear all appeals which arise within that act, that is under section 421. Every order which is passed under the Companies Act can be appealed against to the NCLT, where unless of course a special separate remedy is given, like in 252. If you ask me whether under 252, 252.1 and 252.3 remedies are given. So if I miss the deadlines there, can I go under 421? The answer is no. The answer is simply no, for the reason that where the Act provides for an express remedy, then the general remedy will not be available. So therefore, for in every instance where a remedy is not being provided for under the Companies Act, 421 an order, NCLT will have NCLAT will have jurisdiction. Of course, this is in the context of even for a 252 order, 252.3 order, that is of the NCLT, against a 252.3 order, 421, you will only go before the NCLAT. So the appellate provision remains 421. Then, by virtue of the Finance Act of 2017, there was what was called consolidation of tribunals. A lot of tribunals were extinguished. Other tribunals' jurisdictions were conferred on NCLAT. Initially, if you looked at the Competition Act, you had what was called the Compact, Competition Appellate Tribunal. The last judge of the Competition Appellate Tribunal, if I am wrong, was Justice Singhvi. If I am not wrong, was Justice Singhvi. Subsequently, by virtue of the 2017 Act, what they did was they extinguished the tribunal and they said all orders of the CCI shall be appealable to the NCLAT. So that would be your 53N. Subsequently, of course, with the advent of IBC, section 61 of the IBC provides for appeals. These are the three broad appeals. Of course, there are other appeals which I think my learned colleague Mr. Pawan will be dealing with in detail. So, qualification of members to the NCLAT. I would like to draw your attention to the points which have been bold and highlighted, because there is a controversy which has recently come up by an order of the NCLAT which I would like to address on. So, if you look at section 411 of the Companies Act, it says a person who is or has been a judge of the Supreme Court or a Chief Justice of the High Court shall be a chairperson. So, if I am a sitting Supreme Court judge, even then I will be entitled to be appointed as a chairperson of the NCLAT. A judicial member will be one who has sat as a judge of the High Court or a judicial member of the tribunal, which is the NCLT, for about 5 years. A technical member is a person who will have special knowledge and professional experience for about 25 years. So, this is the question. Given the constitution of the NCLAT, which is superior? Is it the NCLAT which is superior, or is it the High Court which is superior? Recently, what happened in the Bhushan Power case, the NCLAT directed the NCLT principal bench in Delhi to not follow an order of the Punjab and Haryana High Court and said, you follow only the NCLAT or the Supreme Court's order. Today, if that order were to be followed by the principal bench of the NCLT, if it followed the NCLAT's order, it will be in violation of the High Court's order. If it follows the High Court's order, it will be in violation of the NCLAT's order. Both of them have powers of contempt. The High Court's order cannot be quashed by the NCLAT because there is no appeal against the High Court's order. In such a situation, which is superior? Today, for example, if the NCLAT is constituted in Chennai, is the NCLAT to be understood as being over and above the High Court, or within the supervisory jurisdiction of the High Court, or both as being independent bodies whose jurisdictions cannot be encroached by one another? What is the role that you take? So, the consequences of the decision are this, whatever I already addressed. So, is this answer correct? Is the NCLAT over and above the High Court? The answer is no. The High Court is supreme for three reasons. One, the NCLAT is a statutory body, whereas the High Court is constituted under the Constitution of India. It's a constitutional body. Second, there is in law what is called a Grun norm theory, where the highest norm, and from there on, for example, no law can supersede the Constitution, no delegated legislation, no rule can supersede an act, no government order can even supersede a rule. So there is a hierarchy. So what the NCLAT is a body created by a statute, which is second in hierarchy. What the High Court is a body created by the Constitution itself, which is supreme. Therefore, within the constitutional frame, the NCLAT, which is a statutory body, cannot supersede the High Court. That is one argument. The other argument is this. The counter argument, which was presented by the learned chairperson of the NCLAT when he was here in Chennai for the IBC seminar, was this. He said, under section 411, a sitting Supreme Court judge can be appointed as a member of the NCLAT. Therefore, his office is a constitutional office. Can a High Court judge or the High Court pass any directions to the Supreme Court judge? The answer is this, in our view. Of course, it has not been settled, but I think we can have a discussion on it. What 411 postulates are qualification. For example, it says if you are a Supreme Court judge, you are entitled to be appointed as a chairperson. That is qualification. That is like saying if you have a BL or if you have an LLB, you are entitled to be enrolled as an advocate. That does not mean that I exercise the powers of the Supreme Court when I am sitting in the NCLAT. For example, we all have this concept of what is called judicial review. For example, whether the IBC can be challenged and held to be unconstitutional, or can the Companies Act be challenged and held to be unconstitutional by the NCLAT? Of course not, because it is constituted by that act. But can the High Court do it? The Supreme Court do it. Therefore, the mere qualification criteria alone is provided in 411. What is not provided is the power. It cannot mean that wherever a Supreme Court judge sits, there he exercises Supreme Court power. The powers of the Supreme Court. The powers are attached to the office and not to the person. If he sits in the NCLAT, the powers that he exercises are that of an NCLAT's judge, which is only statutory power. The third, under Constitution, you have what is called Article 227, which provides for supervisory jurisdiction of tribunals. The High Court exercises supervisory jurisdiction over all tribunals within its territorial jurisdiction. There is no bifurcation made as to the qualification of the members holding office in the tribunal being the basis for the High Court exercising supervisory jurisdiction. Therefore, on all those three grounds, at least I am personally of the view that it is the High Court which will supersede the NCLAT and not vice versa. So that, yeah.
But then the Punjab Haryana High Court was jurisdictional High Court. It exercises control over the tribunals within that territory. So Punjab High Court is not the territorial High Court. So the NCLT is competent to pass an order.
Okay, let me put it this way. So the Punjab and Haryana High Court might not have been the territorial High Court for the NCLT principal bench, and therefore it need not be bound by the NCLT principal bench is one submission that you are making. Today, all of us have dealt with listed companies. There is SEBI. Where does SEBI sit? So, if the Madras High Court passes an order, is SEBI bound by it or not? Do you challenge SEBI orders in the Madras High Court? Where does the ED sit? Principal office in Delhi. Do we not challenge ED attachment orders in Chennai? The answer is simple. The answer lies in Article 226(3) of the Constitution, which says that an order of the High Court can also extend to all administrative and executive authorities which operate from outside of its territory but have an impact within its territory. This was a case where the Punjab and Haryana High Court, while exercising jurisdiction, had felt that there is something wrong here. See, the judgment may be right, the judgment may be wrong. Now, against the Punjab and Haryana High Court, there is a division bench appeal that was available, or the Supreme Court order that was available. Today, by virtue of the NCLAT's order, the NCLAT's order remains, but the Punjab and Haryana High Court's order has not vanished. Both orders remain. Today, they are conflicting orders. Therefore, there is a risk of contempt running on a subordinate tribunal. The only remedy should have been for the COC to have preferred a division bench appeal, or to have gone to the Supreme Court saying the Punjab and Haryana High Court has heard, and there is no way in which the NCLAT could have said don't follow order of the High Court. There is no option of doing something of that nature. So that's one view which probably we could do. So approach towards preparation of an appeal. So this is quite important, and at the same time it can be a bit theoretical. The reason why I am dealing with this here is this. Lot of us have done work in the NCLT. In the NCLT, the client comes, gives us bundles, briefs us, says, sir, these are the documents, have a look at this, prepare an application, go. We go based on the documents, what best argument is possible, we go. But in appeal, we are not doing that. In the High Court, in the NCLT, we are trying to convince the judge or the court that our party is right. In appeal, you are not just doing that. You are trying to convince something else. What you are trying to convince the court is that the subordinate court was wrong. What you are trying to convince them is that the NCLT fell into an error and that error needs to be corrected by you. So therefore, the principal document in any appeal is the order you are impugning. This is something which during my days with my previous senior, he used to tell me. When you open a document before the Supreme Court, when you try to argue something before the Supreme Court, which is the Supreme Appellate Court in the country, the first document you open in the file is the impugned order. You see what the High Court has done or what the lower court has done. It is only basis that you decide what you are going to say in the Supreme Court, because it is going to correct the error which is crept in. So what you seek to establish is an error in the order against which you are appealing against. So keeping that in mind, these are some principles I think which we must keep in mind. So what is an appeal in law? In law, an appeal is the process in which cases are reviewed, where parties request a formal change to an official decision. Appeals function both as a process for error correction as well as clarifying and interpreting the law. An appeal in Indian law is a statutory remedy. This is very important. If the law does not provide you with the right to appeal, you don't have any inherent right to appeal. For example, if the Companies Act had said the NCLT's decision is final and binding on all parties, no appeal shall lie against it. We are all bound by it. We don't have a body called the NCLAT. We don't have any right to appeal. The only remedy we will have is a constitutional remedy, which is filing and going before the High Court and filing an application, filing a writ, or appealing against that order in a special leave petition under 136 of the Constitution of India. Apart from constitutional remedies, a right to appeal is always a statutory right. And a right to appeal, so therefore the right to appeal can be constricted or expanded because it's a creation of a statute. If you compare two provisions in the IBC itself, you will be able to see what the difference is. If you take section 61.1 of the IBC and 61.3 of the IBC, you will see that 61.1 provides for an appeal with no restriction. So it can be an appeal on question of fact, on question of law, or both. Whereas 61.3 has to be read with 32. 32 talks about appeals against the approval of a resolution plan. If a resolution plan is approved by the NCLT and you choose to appeal against it, you can't appeal against it on any ground as you may please. You can appeal against it on 5 grounds. Those 5 grounds are mentioned in 61.3. If you are not able to file an appeal establishing that an error on one of those 5 grounds are established, there is no appeal at all. Your appeal will get dismissed. Let me put it this way. For example, during the CARP process, quite a few of you, maybe RPs, you have filed, some operational creditor has filed a claim with you. You have admitted the claim, but you have admitted quite late, towards the end. His claim has not been considered in the resolution plan. The resolution plan is approved, NCLT approves it. That operational creditor chooses to appeal before the NCLAT. Is it a material irregularity, so much so that the resolution plan itself should be set aside? Of course, this is wrong. That is wrong. But will the NCLAT set aside the approval of the resolution plan on that ground? The answer is no. Unless you can show one of the 5 grounds mentioned in section 61.3 have been established, or one of the 5 errors mentioned in 61.3 has been committed by the NCLT, there is no question of an appeal being allowed by the NCLAT. Appeal is a statutory remedy. You can appeal. Nobody can stop you from appealing. The NCLAT cannot say that, no, I don't think this appeal is maintainable, I will dismiss it. There is no question of maintainability. But you will not succeed in the appeal. Appeal is not a discretionary remedy, it is an available, valuable legal right, but you do not have a right to succeed in the appeal. What you have is to establish that one of the errors mentioned or the scope of inquiry mentioned, some error is corrected. So keeping in mind the ambit within which you can appeal is very important while drafting an appeal. How to approach an appeal? So here I would have used the term appellate brief. Appellate brief is how to draft an appeal basically. An appellate brief is a document submitted to an appeals court by a lawyer. It contains all the legal arguments as to why the lawyer's client should win the case. Its purpose is to persuade the judges to rule in their client's favor. Unlike in a trial court, that is the NCLT, where as professionals we are free to set up a case, for an appellate court, the motive is to convince the court that the higher court that the subordinate court fell into error while passing the impugned order. Thus, unlike in the NCLT, where facts of the case determine the strategy to be adopted for drafting the application, in an appeal, it is the impugned order which forms the basis of how you will draft the appeal. You will take that order, see where the error has been committed, from there on build your case to convince the court that this is where the lower court fell into error. That is of course not to say that facts are not relevant. Facts are relevant, but now your facts will see, like it's like this. For example, if I tell you that I took 2 lakh rupees from you, I had to pay it back within 1 year. I paid it back, but I failed to do so, and therefore you have gone to the NCLT, IBC, and you have done something. The petition is dismissed. It is dismissed on the ground that it is disputed. Some operation. Me as a lawyer, I filed something. In such a case, the fact that the 2 lakhs had to be paid might have been admitted, but there might have been some discrepancy which would have arisen in the context of the services provided by me, which you would have highlighted, and therefore the petition would have been dismissed. When I prefer an appeal, I need not prove the fact that I raised an invoice. I need not prove the fact that yes, that money was due. I need not prove all of that. All that I need to prove is there existed no dispute, because the remaining facts have already been admitted and established before the lower court. In the lower court, you have to establish all the facts. In the higher court, you only have to establish the facts on which the lower court has disagreed with you. Therefore, that is why your impugned order is most important.
See, excuse me, the income tax appeal, the taxpayer has to pay some amount and all. Is it applicable here also?
No. Sir, the income tax appeal is again, in the context of IBC, this is where I think tribunalization has a great distinguishment to make. If you look at the ITAT is always between government versus individual. It is never individual versus individual. Whereas in the NCLT and NCLAT, it is individual versus individual. Therefore, wherever it is a matter of recovery of money for the government, it is entitled to provide for it. Similarly, if you look at the Sarfazi Act, in the DRT, if you want to file an appeal against an order of DRT, 75% prerequisite. Therefore, where the law which provides you the right to appeal also says that some pre-deposit has to be made, there alone it will apply. 61 IBC does not say so. It might be 421 also, the Companies Act also does not say so. Unless the Act says you have to make a pre-deposit, there is no mandatory requirement for making a pre-deposit. Now, in fact, even in the context of MSME, I think when you challenge an award of the MSME, under section 19 of the MSME Act, headed 34 of the Arbitration Act, you are required to make a 75% pre-deposit. And that the Supreme Court in Goodyear's judgment has said, it is mandatory. So where the statute provides, yes. In all other cases, no. That's how you have to take it.
Facts not considered can be taken in...
Yes, sir. If, again, in the context of section 61 of IBC, facts not considered is relevant. If you look at section 61, it says any person aggrieved by any order of the adjudicating authority. So any person aggrieved, that means even a third party can take an appeal. And on any ground, against any order. So the grounds are not constricted. So in law, how we take it is, when a right to appeal is provided, unless the extent of the court's power to review is constricted, the court is entitled to review in toto. If you compare section 61 and 62 of the IBC itself, which is appeal to the NCLAT and appeal to the Supreme Court. The appeal to the NCLAT is generic. It says against any order, any person agreed by any order. But if you look at section 62, it says on a question of law. So the appeal to the Supreme Court is restricted to questions of law, whereas those words are absent in 61.1. Therefore, on any question of fact, on any question of law, including non-consideration of fact and non-consideration of particular law, an appeal against an order of the adjudicating authority in the NCLAT will always be maintained. That is 61.1. So we have what is called 10 commandments of writing an appeal brief. So I'll just quickly run through them. The first and foremost is that the appellate brief writer should put himself into the shoes of the judge. There is one person or two people who you need to convince in the appellate court that the man sitting below was wrong. So what is it that he is going to be convinced of to say that the lower court was wrong? If you think from that perspective, you will be able to identify what the errors in the lower court's judgment were. That is the first thing you need to do when you take an appellate brief. Second, learn the rules of the appeal and scope of the appeal which you seek to represent. This is important because, like sir asked me, is omission of a particular fact relevant to be considered an appeal? It depends on the facts in some cases. For example, I have filed an application under section 7 of the IBC or section 9 of the IBC because there is more scope for dispute. Some fact has been omitted and the company has been admitted into CIRP. In such a case, under 61.1, omitted questions of fact may be relevant. Now, let's take an alternate scenario where a resolution plan has been approved. Now, your appeal is still maintainable under 61.1, but the grounds of appeal available to you are restricted under 61.3. Material irregularity, misconduct of the RP, contravention of any provision of law. The fact that any fact might have been overseen by the RP is irrelevant there. Therefore, if you say this fact has been overlooked by the RP, is that a ground for allowing the appeal? The answer will be no. Because the rule on the basis of which your appeal is set up does not give you the scope to make that argument. Your argument is restricted to violation of any law, material irregularity, or misconduct by the RP of any sort.
So can I put it the other way around? I can say 61.1 omission of facts. I can put it under 61.3 as a material irregularity, or 61.1 prevails over 61.3, which.
So there is no conflict. See, in law you have what is called a substantive provision and a procedural provision. The right to appeal is a substantive right. So the right to appeal exists, but the scope of review, that is the jurisdiction which the appellate court can exercise, may be provided in another provision. So the scope of review which the appellate court will exercise, the jurisdictional scope, is 61.3, whereas your right to appeal arises only under 61.1. So they operate in different fields. See, for example, I file a writ petition. Now my right to file a writ petition is 226 of the Constitution. But what jurisdiction the court will exercise while hearing that writ petition is in an altogether different provision. Similarly, my right to file an application under 65 is my right to file. But what is the scope? Scope's provision is 61.3. Right provision, the substantive right, is 61.1. That is the difference. So the third point is identify the questions for which the answers may be favorable to your client. So if you look at the format provided for an appeal, which is NCLAT Form 1, you have portions like questions of law, grounds. So there are certain questions which you feel are in your favor. So when you frame that question in your favor, you might be better off because the appellate judge will have that question in mind while reading the impugned order. Or he might have also read the impugned order, then he will go back, read your grounds and come back to read the impugned order again. For example, I'll tell you one case. So this was a case where a person was a financial creditor. this company had already been admitted into CIRP. He had given land to this corporate debtor to build a building, like it happens in our real estate deals. So that person said, he had also independently given a lot of money to the company. Those facts were admitted. He was given a seat in the COC. One of the banks in the COC took an objection saying, he is a related party, because he gave you land, he is a partner to you. The NCLT felt, yes, he is given land, you both are partner, you are a joint venture company. So you both together are a joint venture, therefore he is a related party as partner under section 524M. That was the decision. I had to take it in appeal. Now what is the question of law that you will take? The question of law that you can take is whether I am a partner. But is that the question you want the NCLAT to answer? In my view, no. I may be a partner, I may not be a partner. The question I wanted the NCLAT to ask itself was whether can such a transaction be considered one of partnership itself? Because I found a 2008 Supreme Court judgment which said a person who is contributing land for joint development is not a partner, but is a consumer under the Consumer Dispute Act. If I am a consumer, I can't be a partner. Therefore, the question I wanted the NCLAT to ask itself was not on a question of fact, but on a question of law. I wanted it to ask itself, can this be even termed a partnership? If it can be termed a partnership, okay, I am a partner, I'll walk out. Because of course I have given my land, he's selling UDS, all of that is there is mutual agency. But if this were the question to be framed, you have a better case to argue. So therefore, deciding on how to frame the question of law which you want the appellate court to ask itself is very important. So that is something you need to learn. The next point is questions which are framed must be those which you want the appellate court just to ask itself. That's it. Don't ignore facts or law which are against your client. This is most important because normally the facts which go against your client are often the ones which have been relied on by the lower court to write the order against you. In the very same example I gave you, the fact that I had contributed land and the fact that he had built something on the land and dealt with my land on my behalf became a ground for writing the order against me. Now I admit to all of those facts and I ask the question, am I a partner? So I am not shying away from facts which are against me, but I am challenging the conclusion which has been arrived on, admitting all those facts. I always normally tend to have a better chance of succeeding in appeal because those findings of facts cannot be disputed. Normally facts is in an era of documentation and emails, almost everything is documented. You send a message on WhatsApp today that it's a document capable of admission. 65B Evidence Act will say, yes, this is a document capable of admission. Today courts are allowing summons to be served on WhatsApp. In an era of electronic, digital India, I think there is nothing which is off records. Anything and everything can be proved. Given that that is the situation, it is not possible quite often to shy away from facts. But it is always possible to put facts in perspective in a manner in which it is favorable to you. Therefore, never shy away from facts, but build a story and accommodate those facts in a manner that fits that story, which is your best case in the appeal. That is very important. Highlight the injustice or wrong which has been caused to your client as a result of the trial court judgment. In the same example I gave you, I have contributed land. For the land I have gotten no money. I have filed a claim in the COC, in the CIRP. My claim is admitted, but I am a related party. I am an unsecured creditor. If the company goes into liquidation, I get no money. I have lost my land, I get no money. I have not been involved in the business at all. By virtue of the order being passed against me, substantive prejudice or rights of mine have been affected. This kind of prejudice has to be established in the appeal document, appellate brief. When you are able to establish this kind of prejudice in your appellate brief, the prejudice is not arising out of the conduct of the other party, but the prejudice stands sanctioned by the order of the NCLAT. And the order of court can cause nobody any injustice. There is a Latin saying which says, actus curiae neminem gravavit, which means an act of court cannot harm anybody. Given that an act of court cannot harm anybody, all lawyers and all judicial members are trained with this. Therefore, being able to point to the prejudice or wrong that has been caused to you by the order of the NCLT will be something with which you can project in an NCLAT appeal. So, the other thing which you can often do is to identify inconsistencies in the order of the NCLT. For example, there may be one finding of fact at one place, but the conclusion in the end will be contrary to you. So, it may not be in all cases, but in some cases there may be such inconsistency. In some cases there may not be inconsistencies, but you may be able to say they are inconsistencies. At the end of the day, lawyers do project their cases in that manner. And you must be able to identify those inconsistencies. Despite finding here saying this, he's gone on and done that. Powers. So that kind of inconsistencies are to be identified. Next is identify the inconsistencies in approach between the appellate court and the subordinate court. This is very important. If you look at the recent trend of the NCLAT, if you read their judgment in the recent past, Justice Mukhopadhyay has this idea of revival at all costs and equality at all costs. In the SR judgment, what he says is, you may be a secured creditor, you may be an unsecured creditor, you may be an operational creditor, everybody is entitled to 60%. That is equality for all. If everybody gets identical treatment. When this is the approach of the appellate court, there was another resolution plan which was approved in Chennai, where financial creditors was given 25%, operational creditors were given 15%, and the government income tax department was given 0%. I took it on appeal. Immediately the court stayed it. The court stayed it because the approach which the NCLAT had was one of equality and identity, whereas the approach which the NCLT had taken to itself was lenience to the COC. The NCLT had said the commercial wisdom of the COC is supreme. K.K. Shashidhar says I can't interfere with it, therefore I will not interfere with it. The NCLT was right. And to some extent, yes, the Supreme Court has said you can't interfere with the commercial wisdom. But the approach of the NCLAT, in accordance with the IBC according to it, is to say that there has to be identity or equality. Therefore, highlighting the difference in approaches can also get you orders in that manner in the appellate court.
So can it be against the waterfall concept of settling the creditors?
Sir,
because what is restricted as far as the OC is concerned is restricted to the liquidation value in terms of settlement. Can a court go against what is provided in the law?
Sir, let me put it this way, sir. If the amendment which has been cleared by the cabinet last week, which provides for 330 days and secure creditor, unsecured creditor, operational creditor, all of that distinguishment and all of that, then yes, what you are saying is right. You cannot have a 53 mechanism which is contrary to the 53 mechanism. That appears to be the intention with which the parliament wants to go. Having said that, can you find fault with what the NCLAT has done? My answer is not so much. If you look at the judgment of the Supreme Court in Swiss Ribbons, while upholding the constitutionality of IBC, what the Supreme Court says is the IBC envisages equal and fair treatment to operational creditors. In a case where financial creditors are taking 92%, would it be fair to simply give operational creditors 10%? Of course, I don't mean equality and identity to mean equality and fairness to mean everybody should get 60%. Of course not. A secured creditor has better rights in law than an unsecured creditor. I agree. But a resolution plan being operative in REM and an operational creditor not having any say in the COC, the financial creditors are no longer sitting in their capacity as banks or financial institutions, but they are sitting as trustees for the interest of all the stakeholders in the company. The IBC provides for revival of the company. That is the logic which the Supreme Court has taken. Of course, you can deny it, you cannot deny it. It can be recovery. Some quite senior people are taking a view that yes, the idea of IBC is recovery. But if the idea of IBC were only recovery, then the mechanism which was previously given under the Sikh Industrial Disputes Act, SICA, need not have been made available across the board to all companies. If you look at previously Companies Act 56, you did not have a two-stage mechanism. It was just winding up, provisional liquidator, final, this, you're done. Whereas here, you have a first mechanism of revival. If you are not able to revive in the 270 days, then liquidation. Therefore, there is a marked shift in legislative intent. The legislative intent was, like in all other Sikh companies, like in SICA, what we were trying to do, which had failed because of the lack of a time-bound mechanism, should be established and appropriate towards all other companies. Today, that's why the government has said twofold. It is revival. It cannot be anything else. Sir, ultimately, if we killed all the industries, well, the rate at which for 1 lakh, if you can file IBCs and if you killed all industries, what industry is going to thrive in India? You can take pound to pound, penny to penny, flesh to flesh. But at the end of the day, no blood will remain. It's quite a bit like Merchant of Venice, unfortunately. So, a thorough study of prior precedent can help. And of course, you will have to edit, re-edit and repeat to keep your appeal concise. This is most important. You know, for most of us who's dealt with the NCLAT, after the order is resolved, it is quite often possible that judgment comes after a month or two. They are also overburdened. They are the only tribunal hearing from 10 benches. So, is the court going to remember what one person argued 2 months back? I would honestly think that human memory with all its frailties may not be able to do that. So, what they read is your appellate brief. If your brief is good, if your brief is exhaustive and your brief is concise, you will get through with all the points to the appellate court. If you drag on for 65 pages, he is not going to read it. He does not have the time. By the time he reads your 65 pages, you would have passed 3 orders. So, keep it concise. That is most important. So, presentation of an appeal. You know, normally when we go before the NCLT, most of us, at least what I do is, I first open the application. I show him, this is the corporate data. This is the amount due. This is how the default is come. And if I am for the respondent, I say, this is a section 9, the disputed debt is not permissible. This is the email by which dispute is established, this document, that document. So we always tend to either start with the document or with the application itself. In the NCLAT, in an appellate court, that is normally not how we do it. Of course, there are multiple strategies, but I am trying to tell you one which you can say is advisable by virtue of what some of my seniors have told me. Where you start with is the impugned order. This is a rule which across the board in several places they try to follow for what you need to argue in an appellate court. It is called the IRAC rule. Issue, rule, application, conclusion. You first identify the issue. That is where the court has gone against you. Then you identify the rule on the basis of which they have gone against you, or the rule that they have omitted in going against you. You apply that rule to the facts of your case and conclude by showing the court how the lower court went wrong. Of course, you will stand on your own facts. Lower courts don't go wrong very often. They do apply them and you do put pleadings in and they do pass detailed good orders. And we are quite fortunate to have quite great members here in the NCLT Chennai bench that not many orders get overturned also. But when you are doing an appeal, how you do it is by showing them that this was the issue which had to be dealt with by the lower court. This is the rule it ought to have applied. This is how it applied it, whereas this is how it ought to have applied it. Conclude by showing how that application was wrong. So it comes streamlined and your presentation is concise and straight. This is some rule which is advisory which you may consider following. So yeah, that's pretty much what I've said that's there. So appeals under IBC. So now after all the theoretical advice, we'll probably talk law. So under section 61, there are three kinds of appeals which you can envisage. By three kinds, I don't mean three different provisions under which you can appeal. I mean three kinds of appeals where the scope of review of the NCLAT are different in different contexts. One is 61.1 per se. The other is 61.1 read with 61.3 and 32. That is an appeal against an order approving a resolution plan. The other is 61.1 with 33 and 61.4. An application where liquidation has been ordered. You are going in appeal against an order of liquidation for which your appellate grounds are limited to those mentioned in 61.4. Let me put it simply this way. If it's an order of approval of resolution plan, your appeal is restricted to the grounds mentioned under 61.3. If it is against an order of liquidation, your appeal is restricted to the grounds under 61.4. In all other cases, your appeal is on a question of fact, on a question of law, or both. So these are the three kinds of appeal. So 61.1 per se. So it says an appeal can be filed by any person aggrieved against any order of the adjudicating authority. The limitation period prescribed for it is 30 days from the date of receipt of certified copy of the order. The condonation of delay is restricted to 15 days. After 45 days, no appeal will be maintainable to the NCLAT. On the 46th day, there is no appeal. You can't file an appeal, you have lost your statutory right. Person aggrieved may file an appeal. The term person aggrieved has been defined by the Honorable Supreme Court in this judgment by saying a person aggrieved must be a man who has suffered a legal grievance. A man against whom a decision has been pronounced which has wrongfully deprived him of something, or wrongfully refused him something, or wrongfully affected his title to something. Therefore, if your wrong is not a legal wrong which has been committed to you, you are not a person aggrieved in the eyes of law. So, when can there be a legal wrong? A legal wrong can only exist when there is a legal right to something. For example, I own a property. If in a resolution plan, I have leased it to the corporate debtor. In a resolution plan, it provides that for the next 25 years, the property will be leased to me free of cost. Are you bound by it? How are you bound by it? Are you at least aggrieved by it? Yes, because you have a right to the property, you have a right to the rent to the property, you have a right to let out the property. And those rights have been taken away in a resolution plan. Therefore, you are entitled. For example, say to the contrary, there was a house in the name of the company, the house owner was staying there, you were peeping into the house. By virtue of the resolution plan, the house has been sold to somebody. Can you say, now I cannot no longer peep inside the house because he is no longer going to be there? You never had a right to peep into the house in the first place. So the establishment of a legal right is essential for you to be a person aggrieved. You must have a right, that right must have been taken, should have been affected in any manner, not taken away, affected in any manner. That's when you are a person aggrieved in the eyes of law. In the context of IBC itself, it says it is not restricted to the director, promoter or creditor of the company, but any person who has been prejudicially affected by the order can appeal. An employee, a guarantor or any other stakeholder. So even the government can. Even the government can. The Labour Commissioner can. Anybody can. So any person aggrieved. Okay. So what is said is, if you look at section 65, it does not talk about any person. It talks about any application. On the following grounds can be made. By whom? 65 is very silent. So in that context, the NCLAT has said, the person aggrieved which is mentioned in section 61.1 will be the person who is also entitled to go under 65. If only I can approach the NCLT, can I come and appeal against to the NCLAT? If I never had a right to go to the NCLT, where is the question of me being able to come to the NCLAT? So there appears to have been an error in drafting that section. So by filling in the gap, the NCLAT has now said, any person who is entitled to file an appeal under 61.1 will also be a person aggrieved to file an application under 65. So that is the judgment which says that. Nature and scope of appeal. So what do you mean by nature and scope of appeal? Like I already told you, there are three kinds of appeal. 61.1, 61.3, 61.4. So the importance to understand the nature and scope of appeal lies in the fact that the extent of review is limited to the scope of appeal. If I can go on questions of fact, if I can go on questions of law, if I can go on both, you are entitled to write an appellate brief which covers almost everything. If it were not so, only material irregularity, only public policy violations, then your extent of review is restricted. So it is important to understand the scope of appeal. 61.1 per se is unrestricted in its scope. Therefore, any appeal under 61.1, unless it is constricted under 61.3 or 61.4, is an appeal which is exhaustive. Questions of fact, questions of law, both, mixed question of fact and law. You can argue anything. It's like a first appellate court. They are entitled to reappraise the evidence in its entirety and substitute their judgment for the judgment of the NCLAT under 61.1. There is no restriction on the extent of intervention which is imposed on the NCLAT. That is the scope of 61.1. So if you look at this is an age-old classic Madras High Court judgment on first appeal, which says all the provisions relating to the appellate jurisdiction of this court are attracted. It is true that all the provisions of CPC may not apply, but because it's a creature of statute, but all provisions applicable to first appeal will apply. That is an extensive inquiry into fact, into law and into both. So that will always be maintainable in the context of NCLAT. The next one. So this is again, first appeal is available, right? All these are to support just this point. Now an appeal under section 32. It's an appeal under section 61.1 read with 32. So this is against an order approving a resolution plan. When I want to appeal against an order approving a resolution plan, I will appeal only under 61.1, but my grounds of appeal will be limited to those mentioned under 61.3 by virtue of what is mentioned in section 32. 32 says, 31 is approval of a resolution plan. 32 says an approved resolution plan can only be challenged on the grounds mentioned in 61.3. 61.3 says these are the 5 grounds. What does it say? It says if it is in contravention with provisions of any law for the time being in force. If I am able to show that an law exists and in some manner the resolution plan is contrary to that law, then the resolution plan is invalid. This is very important in the context of what is called the right to subrogation. If I think sometime last year, the NCLAT in the Satish Kumar Gupta case, if I am not wrong, held that the right to subrogation can be taken away by a resolution plan. What is the right to subrogation? I am a guarantor. I am paying for your debt. So I am entitled to recover that money from the company. I step into the shoes of the creditor. This is a legal right given under 140, 141 of the Companies Act 1872. Now if a resolution plan says you shall not have a right to subrogation, is it not in contravention of any law for the time being in force? But the NCLAT says that is not so, you are entitled to take it. Now, of course, the question has to be settled. How they are going to settle it, I don't know. But those are questions which do arise in the context of this. There has been a material irregularity in the exercise of powers by the resolution professional during CARP. For example, leakage of liquidation value. It's confidential information. You tell the resolution applicant that this is the liquidation value, you file just above this. Or you tell them that boss, this is the bid by the other resolution applicant, you file 20 rupees more than that. So all of that will become grounds for setting aside of a resolution plan. The debts owed to operational creditors or the corporate debtor have not been provided for in the resolution plan in the manner specified by the board. That is, the manner specified by the board is regulation 38, which says that they will be paid in priority to that of financial creditors. And section 32, this is actually a reflection of section 32. If you look at section 32 and if you look at section 61.3, under section 32 for a 30 clause 2, for a resolution plan to be valid, there are 5 grounds mentioned. For a resolution plan once approved to be set aside, there are still the same 5 grounds mentioned. The only additional ground is that material irregularity is kept in. Apart from that, there is no additional ground. So what the NCLAT does in appeal is, it only sees whether the restriction or constrictions mentioned in 32 have been correctly applied or incorrectly applied by the NCLAT. Nothing further. I mean, not clear on that one. Do you want me to repeat it by any chance? I'm clear. So the next one is, the CARP cost should have been provided in priority, naturally. Next one is, does not comply with any other criteria specified by the board. They have not specified much criteria. So it says, as is evident from a mere reading, it is clear that the grounds of appeal are limited to those mentioned in 61.3, and a person cannot challenge a resolution plan on any ground other than those mentioned under 61.3. Those grounds are exhausted. 61.3 is a direct comparison to 32, 30 clause 2. However, 61.3.2, that is misconduct by the resolution professional during CARP, is alone an independent ground for appeal. Of course, but that is not to say that under 32 or for approval of a resolution plan, it is not available. It is like this: when you give an advertisement for getting a person to be appointed into something, you will say he has to have this degree, he has to have that degree, he has to have experience, he has to have this, he has to have that. You never say that he has to be a person of integrity, a person who is trustworthy. It's all inherent. If you fail in the process, you fail. So those are things which are always, when a law provides for something to be provided in a particular manner, the failure to do so in that manner is always a ground to reject the conduct which has happened in furtherance to that law. Therefore, in my view, even 32 should be understood to mean that yes, you should have followed the process. Just because it is absent in 32 and it is absent in 61.3 does not mean that it cannot be a ground for to challenge here, it cannot be a ground to challenge here, and it will be a ground to challenge there. Of course, it will be a ground to challenge everywhere. That will become the question. So in Arshal or Mittal, the Supreme Court itself has said the grounds are exhaustive, it is limited. So now that point of law is settled. Against an approval of a resolution plan, the grounds mentioned in 61.3 are limited. So that point of law gets settled in Arshal or Mittal. So appeal against an order of liquidation. This is pretty much like 61.3, but here the grounds are further restricted. It says material irregularity or fraud which has crept in. This I can explain by an example. Say for example, now the cabinet has approved a provision which says that I need not wait for 180 days or 270 days to send the company into liquidation. If on day 30 I think that this company is not worth it, I can send it to liquidation. Assume a cantankerous promoter who says, boss, I am all debt ridden, but all my debts are unsecured debts, the company has a lot of value, I will create a financial creditor. I will admit into CARP. I will, once the CARP is admitted, 30 days I will wait, I will take the company into liquidation. The financial creditor will be the only secured financial creditor. Under 52 he will exercise his rights. I will keep him out. Everybody else, no money. Nothing else left in the company. What do you do in such a situation?
Challenge it. It's a fraudulent act.
Exactly. So the order of liquidation will become challenged as fraudulent. Or you will say there is a material irregularity. So it is to provide only for cases of such extreme fraud that this provision remains to that extent alone. You cannot otherwise interfere with an order of liquidation, because after 270 days, whether you like it or not, liquidation is automatic in the eyes of law. 270 days, whether you have even given your expression of interest or not, does not matter. 270 days is mandatory. On the 270-day deadline, your company is entitled to be liquidated. So, this is in the context of limitation. What happens in those 45 days? 30 days plus 15 days. 15 days for sufficient cause. So, even for the 15th day, or for like if you file on the 31st day, you will have to show sufficient cause as to why you were 1 day late. And after 45 days, that is after those 15 days of extended time, you have no right to appeal after that. This is by the NCLAT. This I think, and the SLP was also dismissed in the Supreme Court. So you can take it as good law, even approved by the Supreme Court. NCLAT rules, forms and formats. If you sleep, I am not responsible. So, appeal under 2C of the NCLAT rules is an appeal under the Companies Act 421. Now after Companies Act 421, when they amended the 2017 Act, through the 2017 Finance Act, they were smart enough to include the Competition Act appeal, the appeal which was previously to Compact, into 421. But they were never smart enough to include section 61 into 421, because they always considered it to be independent. So today, when I file an appeal under section 61(1), if I were to go by the NCLAT rules, it says an appeal under the Companies Act. Now I am appealing under the IBC, where the NCLAT rules apply to me. But all of us are filing forms only which are there in the NCLAT rules. What they must have done is, they must have amended and said, an appeal under this Act means an appeal under 421 of the Companies Act, or an appeal under 61(1) of the IBC, which they have failed to do. But however, I in fact spoke to, I for a moment thought even I might have been wrong, they might have been wiser. I spoke to some 5-6 NCLAT councils who are very regular there. All of them said they only file in the forms provided in the NCLAT rules. So as of now, we all follow the NCLAT rules without a provision saying that we have to follow it. Rule 8 of the NCLAT rule says the sitting of the NCLAT will be in New Delhi. So by virtue of this rule only, we don't have an NCLAT in Chennai. Otherwise 410 does not provide anything. So this rule was challenged by one of my colleagues from my senior's office. In this writ petition, Atiban Vijay was a Union of India. I think one member of the CA Institute had also filed this. Mr. Venkateshwar Kumar, I think, had also filed in this writ petition batch. And the writ petitions were dismissed. The High Court said it is a matter of legislative policy to choose as to where the NCLAT will sit. We find no arbitrariness in it, so we are not going to interfere. However, that became one of the grounds for arguing that the IBC is unconstitutional in the NCLAT, in the Supreme Court in the Swiss Ribbons case. Although Rule 8 was never challenged, they said there is substantial difficulty caused to me in filing an appeal. Therefore, this is a ground for saying that the IBC in its entirety is invalid. The Supreme Court, the government was very smart. They said, why go into all these arguments? We will give an undertaking saying that within 6 months we will establish circuit benches. They gave that undertaking, that was recorded. It so happens, I don't know whether it was intentional or coincidence, the 6 month ends today. So by tomorrow, any of you in this hall can go and file a contempt. So,
we will engage you.
Huh?
We will engage you.
ನಾನು contempt ಗೊತ್ತಿಲ್ಲ. So the rule for forms for filing of appeal. So rule 4 says that the forms prescribed in the NCLAT rule should be used for filing of appeal. Rule 26 says that the registry is to verify if the appeals are in the format prescribed for filing of appeals. All of this is, if it is not, they will return the file back to you. Within 7 days you will have to rectify the defects. If you don't rectify the defects within 7 days, the registrar is entitled to, for reasons to be recorded in writing, refuse to register your appeal. But so it is safer that you do all your corrections in the appeal papers within 7 days. Rule 22(1) of the NCLAT rule says all appeals will be done in form NCLAT 1 in triplicate by the person filing an appeal or any person authorized representative with the requisite court fee. So your concerned form for filing an appeal is NCLAT form 1. The court fee for filing an appeal is 5,000. For any interlocutory application is ₹1,000, and as of today it has to be in the name of P&AO, Ministry of Corporate Affairs, New Delhi. All this will get amended as and when I think we have an NCLAT here, if we have it. The appellant must sign at the foot of each page and affix a seal where necessary. A certified copy is necessary. A certified copy of the order you are impugning is necessary, but in some cases if you are not able to file the certified copy, we file what is called a dispense with. It's an interlocutory application where we seek an permission from the NCLAT to dispense with the production of the original certified copy. You can just give a Xerox. The NCLAT may order it. Because under Rule 15 of the NCLAT rules, the NCLAT Rule 14 and 15, they appear to have the rules to power to dispense with the compliance of anything, any rule whatsoever. So they can dispense with the production of certified copy also. So all documents should be duly indexed. Again, like in the NCLT, you will have to serve prior to all respondents before going to the NCLAT, before going to the registry. So along with all your appeals, you will file what is called a verifying affidavit. They have given a format for the verifying affidavit also. It is NCLAT Form 4. Thus, the following documents are necessary while filing an appeal. If you have these documents, normally your appeal will be in order. You will have an appeal in NCLAT Form 1, all the documents before the lower court along with the pleadings that were there before the lower court, certified copy of the impugned order, verifying affidavit in Form 4, and your Wakalatnama or memo of appearance. If you have these 5, you are normally okay. Computation of limitation under the NCLAT rules. It is just a replication of what exists in Limitation Act. The order was passed yesterday, certified copy was given today. Limitation, when will it start? Will it start today? Will it start yesterday? Will it start tomorrow? The answer is it will start tomorrow. The day on which the cause of action's existence is communicated to you, that day will be excluded, and from the next day, limitation will start. If the 45th day or the 30th day happens to be a Sunday, then if you file on a Monday, you are within limitation. Those are the rules. The concerned rule is Rule 3.
I have a doubt.
Yes.
I don't understand this filing of affidavit. Okay, every time we file something in NCLT, I have to give an affidavit stating it is true. Why are they taking? Isn't it? It's a practical question. Why
No,
do
I
we
understand
need to
it.
waste so much of time, that paper, getting it certified? Because I have already initially the order is given by the court. As a chartered accountant, order is given by the court. I'm filing an application, it gets done, and then every time I go to the court for something, again I have to give an affidavit. Here also you are saying there's an affidavit. So why do they want us to certify every time that yes, what I'm saying is true?
I will tell you. The reason is this. If you look at most provisions which create tribunals, they also say they will have the same status as a court, and false statements in them will be punishable in accordance with 193 IPC, 195 IPC and so on and so forth. If you look at 193 and 195 IPC, it is perjury. When can you say that there is perjury? You can say there is perjury when someone has represented something as true to the court. What do you do in the verifying affidavit? You say, what I have said in this application, what I have said in this counter, what I have said here, what I have said there is true. Therefore, if it turns out to be false and if they find out you have done it wantonly, they will refer you for criminal prosecution to perjury. The reason why they do it is, the act of stating that it is true happens by the verifying affidavit. I have verified everything. See, sometimes what we do is at least in my office, most of us file what is called counter affidavit. So it is an affidavit in first person already signed by the client. So the verifying affidavit, you may say that the affidavit itself is sufficient, that itself is an IIA and all of that. That may be one answer. But in some cases, you have what is called a counter statement, which the counsel signs under instructions from the client. Like for example, a written statement, a plaint. In a plaint, we always draft saying the plaintiff submits, the so-and-so submits. So it is always in third person, it is never I state. In such a case, when you verify it, you are saying, I have seen everything you have stated, I know that you have stated this, I am saying it is true. So it is no longer me drafting under your instructions, you certifying to the court that what you have said is true. Therefore, by virtue of the verifying affidavit, if it turns out to be false, you are entitled to be prosecuted under 193, 195 of IPC, read with 340 of CRPC for perjury.
Sir, can a third party, in knowledge of the commission of the offence of perjury, make an application to the competent court hearing the case, whether a locus standi is applicable for them?
Sir, perjury is always a matter between the court and the individual. That is why for perjury you are always not entitled to go and file a complaint before the police or the magistrate under 200. It is the court first which satisfies itself in accordance with section 340 of CRPC to say that in cases in NCLT Chennai bench, there was a challenge saying that the valuation is too high, therefore the liquidation value is too high, therefore the resolution plan submitted is not able to meet the threshold of the liquidation value, therefore the liquidation value should be reduced. Consequently, it's a challenge to the valuation report. Now, the valuation report is a confidential document. How is it amenable to challenge? I don't know what is in the report. I don't know what has been done. 424 of the Companies Act appears to say that the NCLT or the NCLAT, as the case may be, may have powers to appoint commissions to conduct cross-examination. Now, whether such power can be exercised in the context of IBC, whether the NCLT, while exercising powers under the IBC, can also invoke provisions under the Companies Act to do complete justice and unearth facts of some nature. Given that confidentiality is also involved, in some cases it may be difficult. But in rather easier cases where there is no confidentiality involved, the answer may be yes. The answer may be yes because of what the Supreme Court says. In PK Educational Services, the Supreme Court says, given the fact that procedure that would apply to the NCLT would be procedure contained inter alia in the Liquidation Act, it is clear that the NCLT would have to decide the applications made under the court in the same manner as it exercises other jurisdiction under the Companies Act. That is, by deciding Companies Act proceedings, whatever powers I exercise, I am entitled to exercise even when they decide matters under the court. So yes, it may be possible. I don't know whether it has been done as yet. I know it has not been done in the NCLT Chennai bench, but someday it may happen. So, any questions? I think apart from that, I'm close. No question. Thank you.
Thank you very much, Avinash. It was a fabulous core way, I would say, of IBC, Companies Act, Advocates, Limitation Act, and everything which is practically applicable to us in day-to-day practice. Thanks a lot. I'd now like to request CA Ramji to introduce the next speaker, Pawan. Can Pawan come over here? He's outside. To give the formal introduction and then you can take.
Good evening all. I got the privilege to introduce Advocate Mr. Pawan. Mr. Pawan practices commercial law and corporate law. He passed out from Indian Law Society Pune in the year 2010 and has been in practice since then. He handles insolvency matters, the corporate restructure, amalgamations, demergers, buybacks, acquisitions. He has assisted in the making of the book Mergers and Takeovers by Mr. Pandian and Sridharan, and also in the making of the book Ramaya on Companies Act 2013 edition. He is a faculty member of Institute of Company Secretaries of India and also a faculty member of ACCA UK. And he has been delegated and appointed by the Institute of Companies Secretaries of India to draft and frame the study materials for the company secretaries students in the subject of corporate law, insolvency, corporate restructuring. So with this background, I welcome Advocate Pawan. And may I request Mr. Krishnan to...
A very good evening to all present here. Me and Avinash have been discussing this topic for a long time because it gives us great interest. Because as youngsters, we were in the profession when the advent of IBC came across, and we are just so excited. If we have the NCLAT coming here in Chennai, and apart from that, I have sincere thanks to Ms. Anita. Whenever she's seen us in the NCLT, she's always been encouraging and she's always been supporting and she's always promised us conferences, for people like us who are growing in the profession. This is a fantastic gesture what she's done. My heartfelt thanks to her. So, the topic given is practice and procedure under the IBC under the Companies Act 2013. I had my wonderful colleague dealing with the IBC provisions. I'll deal with the Companies Act provisions. See, practice and procedure is something which we all know. You can buy a book, you can read the papers, you can read the forms. I'll try to bring in, issues which I could see in those rules and forms. It might be a bit mundane, but the selling point I have with you, I'm sure you'll be attracted by that. So I would request you to have real great attention to detail with all the process and procedures, because this is going to be a phenomenal, area of practice for all of us. Okay, this is just a quote which I took out before I start off. With the advent of the NCLAT, God promise or other, God hoping, this comes here to the state of Chennai, to the city of Chennai. So this is a small quote which I would like to start off with. Change is the law of life. Those who look at the past are going to miss the present and the future. This is very, very, might be very philosophical, but I would definitely connect this with the legal profession, or you professionals, or professionals of the CS Institute, because I think our time is here, our time is now. The advent of the NCLT brought us such fantastic opportunities, and I think 80 is going to be phenomenal. So, NCLAT in Chennai, hopefully, and what comes with it. These are the opportunities which I could draw down. A goldmine of an area of practice. Obviously, all professionals are to be benefited. It's a plethora of opportunities. It is going to be the appellate center for the entire south of India. It's going to have a constant flow of litigation and constant flow of work. We also have appeals under the Competition Act. I'll give you the present scenario. I plead my ignorance in knowing the number of NCLTs in India, but I'm sure we all know it'll be like 8 to 10 NCLTs maybe. So every appeal presently from the NCLT or the adjudicating authority goes all the way to Delhi. So that involves significant cost, significant effort. You have to hire lawyers there, you have to hire lawyers here. There's huge cost, jeopardy which happens to all parties. So the way I look at the NCLAT here, apart from the practice and procedure, and the reason why we are here to discuss this, is that just imagine you had the IBC coming in 2016. Okay, no one ever imagined that the IBC is going to throw open so many opportunities. Look at a scenario now where you're doing, the first court level work. Here you're going to do the level of work which is going to be appellate in nature, which is going to be from 4 to 5 prominent states in the south. Okay, you will have to have different offices. You have to have great resources to cater to the needs, because the amount of growth, which I would have seen at the CLB time, and we all know how it grew. It was the CLB, it got into the NCLT. When the CLB was here, you had, for the south, the Chennai being the center. I can only imagine, youngsters and us having such fantastic opportunities. So I would want you to read the presentation or follow the presentation with a mindset of opportunities. I think that will help you appreciate what I would want to put across. So I already told you there's a significant reduction of cost. Obviously, it's inconvenient to all litigants. It's actually very unfair to them, compared to the present scenario. So if the NCLAT comes in Chennai, it's going to benefit all, not only lawyers. It's going to benefit CAs. It's going to be benefiting cost accountants. It's going to be benefiting company secretaries. Okay, there's no appeal expert, but this is something which is offhand I put down. In order to be a good appellant professional, I think domain knowledge is quintessential. Domain knowledge in everything you do is significant. You can't be a good appellate professional if you do not know what happens in the NCLT. So I think you have to be a fantastic person, hands-on on what the loopholes are or what the process is at the NCLT, to understand and to appreciate what would sustain or survive on an appeal. So domain knowledge is very, very important. The process which happens in the NCLT, you have to know it back of your hand. Procedure and the law before the NCLT. If a person is thorough with the law at the NCLT level, being an appellate professional is just easier. The art of framing appropriate and important questions of law and fact. Okay, as Avinash has already told you that, I'll come to that provision of law which is there in the Companies Act in terms of deciding what the appellate authority will do in terms of an appeal from the NCLT. It is equivalent to a first court of approach. The AT might be called as the appellate tribunal. Technically, it will go into question of every fact. It will go into question of every law. So the art of framing is something which is gained only on experience, which will come to all of us. And the last is the most and the foremost important part of being a good appellate lawyer or a professional, the art of analyzing and assessing an impugned order or pleading before the NCLT to be made part of the appeal before the NCLAT. I think apart from what documentation goes on to the NCLT level, you should be a very good analyst of what the impugned order is, because that is where your grounds of appeal or your grounds of question of law and fact will flow. Because at the end of the day, the impugned order is a summation or a summarization of what the judge has said in terms of your pleadings. This is the trajectory of my presentation. I'll deal with the NCLAT rules. Then you have important provisions under the Companies Act 2013 governing the NCLAT. You have appeals before the NCLAT, which are various forms of appeals under 241 and other provisions. You have appeals under the Competition Act. Okay. Just putting down what an appeal is. Okay. In law, an appeal is the process in which cases are reviewed, where parties request a formal change to an official decision, here being the adjudicating authority or the NCLT. Appeals functions both as a process for error correction as well as a process of clarifying and interpreting the law. There's another saying that an appeal in law would mean to put the dice into the box for another throw. This is a simple, basic understanding of what an appeal can be. Why is procedure so important? Procedure goes beyond elementary principles like the guarantee of an unbiased tribunal or the opportunity to present and confront evidence. Procedural law is the collection of rules that govern how courts do their business. All levels and types of courts use procedural law. It controls how courts hear cases. It also dictates what a party must do in order to bring their case before the court. Okay. This is more of a holistic view. What is beyond an appeal and procedure? This is what Mahatma Gandhi said. There is a higher court than courts of justice, and that is the court of conscience. It supersedes all other courts. Let's just go on to the rules. So I call these the rules of mercy and discretion. You have the inherent powers, which is Rule 11 of the NCLAT. What is an inherent power? Is something which is synonymous to the NCLT rules. It permits the NCLAT to pass such orders or directions to meet the ends of justice or prevent abuse of process. So it might be a scenario where it might not be laid down in law. Okay, it might not be something which is visible from judgments, but then there is something where the court sees in the nature of equity, and if you plead equity and the NCLAT or the NCLAT exercises such inherent powers. You have the power to exempt, which is Rule 14 of the NCLAT Rules 2016. On submission exempt parties from compliance of the said rules and directions in matters of practice and procedure. Say for example, you want to dispense with producing certain documents, you want to dispense with producing original order copies. I think this is something which you have to invoke, where the NCLAT can exercise the power to exempt. You have the power to extend time. Say for example, the NCLAT passes orders that within certain time limits, certain processes or certain procedures or compliances have to be done. Then the AT can extend time under these laws or fixed by an order, although the said application is not made within the expiration of time. So this gives you a leeway to make the application even after the expiry of time. But good prudence would ensure that you make an application much before the time has elapsed. You have the rules of procedure. This is quite simple, but based on the limited experience we have before the NCLAT, I think this is going to be paramount importance, because they look into the format, the form, the language, the spacing, the marginalization, the indexation at a very large level. It might be very, very basic, very rudimentary, but this is something which you have to keep in mind. Appeals should be in English, obviously. It permits any other Indian language as long as there's a translation provided. It should be legibly typewritten or printed in double spacing on one side of standard paper. It has to have an inner margin of about 4 centimeters width on the top, with a right margin of 2.5 centimeters, with a left margin of 5 centimeters duly paginated, indexed and stitched. Strict compliance with the same is required, otherwise the appeal papers might be rejected or left for defects and might need to be re-executed. So, I mean, more than when we as lawyers file appeals, I think what we look at is formatting, the process, the procedure, and how the registry will look at documents. I think that's something which is common to all professionals. So I think 80 looks at it at a very, very high level, at a very, very macro level, compared to what the NCLT might do. You have, preparation of the appeal, and then you have the presentation of the appeal. The presentation of an appeal is in a form called the form NCLAT 1, which we all know. It provides you the manner of filing under Rule 22. The appeal should be in triplicate. You have to have the certified copy of the impugned order, sufficient copies for service on the opposite party. In pending matters, all applications have to be pre-served. So this is basically a process, a procedure which you have to follow when you file an appeal. Endorsement and verification, which is governed under Rule 24. At the foot of every appeal or pleading, there shall appear the name and signature of the authorized representative, which is obvious. You have to sign all pages. Whenever in doubt, we always advise our clients to sign all pages, so you sign all pages. Okay, this is quite surprising because you have the act which vests powers on the judge, the chairman, the president, the judicial member or technical member. The registrar actually at the 80 level exercises significant power to even reject your appeal. You have Rule 26, which governs the powers and actions by the registrar. Obviously on filing, you need an acknowledgement, you need a diary number, which will be assigned and given to you. On scrutiny, if the appeal is defective, notice shall be given to the party for rectification within 7 days. So you file the appeal. Once you file the appeal, you get the acknowledgement, you get the diary number, and within 7 days you have to rectify any defect if there's a defect persisting. Then the registrar may for sufficient cause allow time for amendment or rectification to the concerned party with reasonable time. So the registrar can give you time to make corrections or amendments. Say for example, you file an appeal. After filing the appeal, you felt that a certain pleading is missing. You file an appeal and then you realize that the senior counsel has advised you to add certain additional grounds. You have a senior counsel who has advised you to add additional prayers, okay? So this is something which gives you that bandwidth to change the paperwork, because once the appeal is numbered, I don't think you can do anything. You have to move a form and amendment of the appeal. So this might be significant leeway given even to the AT, for orders passed by the AT to ensure its compliance. As far as the company is concerned, it is obviously where the registrar office is located. If it is an individual, it is where he resides, voluntary for gain or for business. Okay, these are the appeal provisions which are provided under the Companies Act. You have Section 421 of the Companies Act 2013 and you have Section 423 of the Companies Act 2013. 421 deals with an appeal from the tribunal. Parties agreed by an order of the tribunal can appeal before the AT within 45 days of the receipt of the impugned order. Appeal before the AT can be made on a question of law and fact. In a sense, the AT can exercise power as the court of first instance. Delayed filing of an appeal before the AT can be condoned if sufficient cause has been shown. I would like you to compare Bullet 2 with 423 of the Companies Act 2013, okay, which clearly says that the appeal from the AT before the Supreme Court can be only on a question of law and nothing else. So it can't go into fact finding, it can't go into what were the facts involved, it is only purely on a question of law. Again, you have delayed filing which can obviously be condoned by the Supreme Court if sufficient cause has been shown. You have the power of contempt by the AT, okay, which is a significant, significant power which can be exercised by AT for non-compliance of any orders. Okay, the AT you have two remedies. You can file a contempt or you can file an execution under 424, which I showed you. So you can initiate a contempt. The AT shall have the same jurisdiction, power, and authority in respect of contempt of themselves as the High Court has and may exercise. The High Court shall be constituted as the AT under the Contempts of Court Act 1971. So basically what is happening is the AT and the tribunal is made synonymous to a High Court, how the High Court is treated under the Contempt of Courts Act. So there is significant power vested by the AT to issue contempt or order contempt. The object behind the contempt provisions being enshrined under 425 might be this. The object of the discipline enforced by the court in case of contempt of court is not to vindicate the dignity of a court or the person of the judge, but to prevent undue interference with the administration of justice. This is certain immunities which are flowing out of the Companies Act, which can be given to members, the tribunal, or liquidators discharging their functions under the Companies Act 2013. No suit or legal proceedings shall lie against the AT, the chairperson, the president, member, officer, or any other employee of the AT or liquidator, or any other person authorized by the AT, discharging functions under Companies Act 2013, which has been done in good faith. So any of these officers exercising their jobs or their obligations and performing their duties under Companies Act 2013, as long as it is done in good faith, there is a certain protection in the form of an immunity given to them. This is very, very interesting because 430 has become a huge debate and there are significant judgments which flow from this. Okay? It clearly says that the civil court will not have jurisdiction on any issues governing the Companies Act 2013. I just extracted what the analogy of section 430 might mean. It bars civil courts from exercising its jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal or the AT is empowered to determine by or under this act or any other law for a timing in force.
So, I have a small.
Yeah.
This section 428, you say that all these people, the previous one, acting in good faith, so no action can be taken on them.
Yeah.
So there is this case where the IPs are also supposed to be officers of the court. So will it be applicable to them?
To a certain extent, you can, look at defending yourself, but
can we take a remedy? Because there are so many things where the punitive action is taken on.
I agree to that, but if you see, I try to defend because I don't think you can intertwine the process of 428 with an IBC proceeding. The IBC proceedings have a different obligation, there are different rules which govern the discharge of officers by the insolvency profession, there is separate regulation on investigation. So you cannot invoke 428 to protect yourself.
Is there a similar provision there?
Yes, yes.
Yeah, that is-
Similar provision is there.
Yeah. So I think they're very distinct. You can't intertwine both. You can't take the benefit of the Companies Act.
There is a similar provision, that's good enough.
Yeah. So I come back to 430. 430 basically means that a civil court cannot entertain any cause of action, any litigation, any proceeding under law, which is governed by the Companies Act 2013. There is a significant judgment of the Presidency Club which came very recently, which our office was handling. Okay, it laid on certain crucial principles on how you view 430 and the power of 430. Under the Companies Act 1956, High Courts were vested with original jurisdiction as a company court to adjudicate certain matters. The reason why this is becoming an issue is because, say for example, you have issues of transfer of shares, you have issues of non-registration of yourself as a member in the register of members. So it's very easy to approach a lower civil court and get orders. Okay, that is why 430 is gaining significant importance. Say for example, you have a dispute under share purchase agreement, you have a dispute under the shareholders agreement. That's purely a company law dispute where the NCLAT has significant jurisdiction under the provisions of operation and mismanagement. That is why this is very, very, very important to understand. The jurisdiction which was divided between the erstwhile Company Law Board and High Court is now clubbed and transferred to the NCLT under the 2013 Act. We all know that. The High Court interpreted Section 241 of the 2013 Act strictly and ruled that High Court with original side or civil courts won't entertain disputes for which a remedy before the NCLT has been provided. So basically it's something similar to a writ petition. If you have an alternative remedy, you can't enjoy a writ petition order, you can't enjoy a writ. Similarly, under the Companies Act, if you have a remedy which is not alternate but that's a significant remedy, if you have that, you cannot knock the doors of a civil court. The powers of the tribunal cannot be termed as summary per se. A summary proceedings would come into place when a court acts upon a common law principle as against a different procedure authorized by law. However, a proceeding cannot be termed as a summary when further procedural strengthening was done by the enactment along with common law principles. As discussed above, common law principles are not given a go-by in the proceedings of the tribunal, but it can go beyond. The intention of the legislature is to redress the disputes, more particularly internal ones of a company within the four walls of the tribunal. This is the finding of the Madras High Court in, I think it's OSA number, I don't have the OSA number, I'll get that for you. I think it's OSA number 29 of 2019, where the Madras High Court has come down heavily to say that the exclusive jurisdiction on a company law issue arises only under the tribunal, not anywhere else. This is the second last leg of my presentation in terms of what appeals can the NCLAT deal with. Okay. Invocation of the jurisdiction of the NCLAT, there are like 7 points, or rather there are 7 avenues in which you can go to the NCLAT. One is obviously an application for inspection of records in the AT. So what you can do is, say for example, you're intending to file an appeal before the Supreme Court and you need documents, and if you're a party to that particular proceeding, your representative can make an application and the AT can allow you to inspect the records. An application for the execution of the order of the AT under section 424(3) of the Companies Act 2013, which we've seen. You have the interlocutory application, appeals from orders of the NFRA, okay? Appeals against objection by the NCLT under 2183 of the Companies Act 2013, appeals under section 241 of the Companies Act 2013, appeals under the Competition Act 2003. The application for inspection of record is governed under Rule 59. Rule 15 of the NCLAT Rules 2016 says that an application for the inspection of records may be made by a party. The registrar shall allow such inspection under Rule 58 of the NCLAT Rules 2016. The said application under Section 59 shall be made under Form NCLAT 3. Application to execute the order of the AT. This is more of the execution proceeding which I was talking about.
Inspection of records cannot be done by a third party.
It says party to the proceeding.
Only those two people.
That's I understand what you're coming to. How say for example you were never a party in a litigation and never made you a party, but how do I get records? But the rule is very clear: a party to the proceeding. But I think if you're an interest party, you can definitely write to the councils and get documents. If it's a part of court records, so you can definitely get it. Section 424(3), the order of the AT can be enforced as if it was a decree made by a court in a suit pending and can be sent for execution of its orders to the court within the local limits of whose jurisdiction. We've already dealt with this. If it's a company, it is where the register office is located. If it is an individual, where he voluntarily resides or carries on business or personally works for gain. And we've already dealt with what the IAs are about. It is governed under Rule 31 of the NCLAT Rules 2016. It is filed in NCLAT 2, which we all know. Okay. This is appeal from NFRA orders. Okay. We all know what the power of the NFRA is. It can, investigate suo moto or on a reference made by a central government into matters concerning professional misconduct, okay, or governing a profession in terms of any firm or a CA firm registered with the Chartered Accountants Act 1949. Any person which is agreed by the NFRA order can appeal before the AT under section 134(5) of the Companies Act 2013. So any grievance caused or a grievance caused on the basis of an NFRA investigation or a suo moto action taken by them, the only remedy for a CA firm or an individual who is a chartered accountant might be to appeal before the AT. This is under 218(3) of the Companies Act 2013. This is basically when a company is under an investigation, either to determine who the owner is, either to determine whether the business or the affairs of the company are conducted in a fraudulent manner, and an investigation has to be ordered under 210 or 213. Then at that particular time there is a provision under 218 which says that a company can approach the NCLT to terminate or remove a certain employee. And if there is a termination or removal of a certain employee which is proposed to the tribunal, which has been rejected by the tribunal, an appeal against such objection lies before the NCLAT. That is what 218 deals with. Okay, these are various subheadings under which you can file an appeal under 241. Okay, change the financial year. I don't think anyone goes on an appeal under this, because now I think the power is now vested with the central government for the change of financial year. All pending proceedings before the ordinance in 2013, that might be dealt with the tribunal. You have fraudulent incorporation which can happen of a particular company. Okay, you can file an application, any interested party can file an application saying that the company is formed fraudulently, and any order against that can be appealed before the AT. I think conversion from public to private is now moved to the central government, but all pending matters before the ordinance in 2019 still vest with the NCLT. Okay. Variation of shareholder rights. Appeal against any order passed for variation of shareholder rights, it can be dismissed, okay, it can be cancelled. variation of rights to a certain extent where it affects voting pattern, okay, that is something you approach the NCLT for its clearance. An appeal against that lies before the AT. Further issuance of redeemable preference shares, okay. Appeal against an order passed on an application under section 55(3) for further issue of redeemable preference shares. An appeal shall lie before the AT on its dismissal by the tribunal. So basically, say for example, you're not able to redeem your preferential shares and you further want to issue redeemable preference shares. You make an application before the NCLT. If that gets dismissed, you go on appeal under 241. This is very common. This is quite a litigation that goes on normally, which is 58 and 59, where you refuse registration of shares. You refuse rectification of register of members. Okay. Appeal from that goes to the AT under 241. An application for consolidation and division of shares. If there is a consolidation or a division of shares happening under section 61, which results in affecting voting percentage, you have to make an application before the NCLT. If there is an objection by other shareholders or the application gets allowed or dismissed against the objecting shareholder, an appeal can lie by any party before the AT again under 241. Application for reduction of capital. Normally 66 is a process-driven mechanism. Normally it is allowed on a filing of the regional director's report. However, there are cases where a reduction of capital has been dismissed. An appeal against that lies under 241 again. Petition on the restriction of liabilities or redemption of shares. An appeal against any order passed under 71(9) or 10 of Companies Act 2013, dismissing or allowing an application seeking to restrict extension of liabilities of the company or redemption of shares. So for example, there is no redemption of shares which is happening, okay, or other redemption of debentures which is happening, okay. But you would want the company not to take on further liability because there is no existing money to even satisfy your own debt. Then you make an application before the NCLT to restrict this. An appeal against this application may be a dismissal or an allowance lies before the AT. I mean, this was a phenomenal 10 years back where there is significant application made for repayment of deposits, etc. It's still in vogue. If there is an application filed under 73(4), okay, for repayment of deposits, okay, or to the extent of damages or losses which you can claim, an appeal against this order lies before the AT again. Application calling for an AGM, it can be allowed or dismissed. An appeal again lies before the AT. Application calling for meeting of members, an appeal lies before the AT. 97 might be a scenario of calling an AGM. 98 can be a scenario where you're calling a shareholders meeting because of some impracticality which exists within the company. Application for reopening of accounts. An appeal against an order passing an application under section 131 seeking the recasting or reopening of the accounts of the company. If this application is allowed, but there's a party who's interested in objecting to this, you can file an appeal before the AT. An application for voluntary revision of financial statements, they can still file an appeal. This, you have 213 petition for investigation of the affairs of a company. I don't think such applications or petitions still lie before the NCLT. There are hardly a few. But if you agree by an order passed in this, you have to go on an appeal before the AT. You have 216, which is a new provision where you have investigation as to who's the true owner or a beneficiary of a shareholding, okay, or rather in order to tap the source of fund, okay, and an appeal against an order launching such an investigation lies before the AT. Freezing of assets of company, where an order can be passed by the NCLT seeking freezing of assets of a particular company, an appeal against this lies before the AT. Very seldom do you see appeals filed against the scheme of arrangement or amalgamation or demerger because normal process which happens, it's a non-adversarial process, normally it gets allowed. Very rarely do you see an appeal, but if there's an appeal under against an order passed under 230 to 240 by objecting shareholders, creditors, etc., then you have to go on appeal before the AT. Okay, waiver application was very, very popular because this is something which had to do with the Cyrus Mystery case against the Tatas. Waiver application is basically when you don't have the threshold requirement under the operation mismanagement sections, then you have to file an application to seek waiver to initiate an operation mismanagement against a company or its directors or other shareholders. Normally it will be waiver first and then the main petition. If your waiver gets dismissed, you go on appeal before the AT and then the Supreme Court. It's similar for an appeal against any case of operation mismanagement. You have class action suits, which is now done only by the principal bench. An appeal against the class action suit obviously lies before the ET. Contempt and compounding provisions, okay, where you agreed when there was no contempt, but contempt is ordered against you, you go in for an appeal. You have compounding provisions where you have violated provisions of law which is compoundable, okay, by fine, okay, which is something which is there under 441 and not imprisonment. An appeal against that lies before the ET. This is the last leg of my presentation in terms of what the NCLAT can do. Okay. This is quite phenomenal because this gets you another stream of law which you would have never exercised. You would always have the Competition Commission of India sitting down in Delhi, and appeals against that would go before the Compat and then the Supreme Court. There is an amendment brought under the Competition Act as well as the Companies Act 2013, which enables the appellate tribunal to hear and dispose of appeals against any direction issued or decision made or order passed by the CCI as per the amendment made to Section 410 of Companies Act 2013 and Section 53A of the Competition Act 2002. Understand that the AT in Chennai would have jurisdiction to hear appeals for companies which are registered within the south of India. So basically, if the NCLAT comes here, okay, and you have competition law issues or you have issues in terms of anti-monopolistic practices, then your source of appeal will be only the appellate tribunal here in Chennai. Okay, strangely, there was a judgment which was passed on the Competition Act and the power which was exercised by the AT in a competition law matter. Here, basically, what happened is, normally if you go and appeal before the compact, you have to give a pre-stay deposit. You have to deposit 25%, 50% of whatever claim is made against you, okay, or a penalty is imposed against you. In this particular case, what had happened is the AT passed an order of a preliminary deposit which was not complied by the party on appeal. Okay, on that particular ground, the AT dismissed the entire case. Since the AT dismissed the entire case, they went up to the Supreme Court. The Supreme Court said that irrespective of your pre-mandatory deposits, this is a statutory right, it's a statutory appeal which vests with the party under 53B, and your non-compliance of that pre-deposit does not entitle you to dismiss the appeal, and you have to go into the merits of the case. I'll just read out the case here. The Supreme Court in the case of Himatlal Agarwal versus Competition Commission of India and others held that an appeal under Section 53B of the Competition Act 2002 is a statutory appeal and cannot be abridged for non-compliance of deposit or payment as a precondition for stay. Okay? The AT dismissed the appeal. However, the Supreme Court held the right to appeal granted by a statute cannot be curtailed by imposing a condition of pre-deposit or penalty, which can result in a dismissal of an appeal if such deposit is not satisfied. In essence, the rule is this: if it's a statutory right given under a provision of law, that will still hold good irrespective of your preconditions to deposit money for stay. Okay. I'll end on this particular saying that if the law is against you, bang on the facts. If the facts are against you, bang on the law. If both are against you, don't bang the judge, but bang on the table.
So thank you very much, Pawan, for taking us through this practice in NCLAT on company law. What I feel is that, chartered accountants and advocates, we go almost hand in hand now. We have to, coordinate, partner with each other so that this benefit of the quote which Avinash gave when Lord Chief Justice Russell was asked what the penalty for bigamy was, he replied 2 mothers-in-law, and he says the penalty for a corporate law practitioner is 2 forums. I don't think it's a penalty. It's more of opportunities for us and opportunities for us to also, coordinate, and we'll have a unity in practice, unify, and we can take it forward. So thank you very much, both of you, for sharing your knowledge and your experience. These 2 budding people have shared their time also with us. Thanks a lot. Let's give them a big hand. Thank you. And let's have more such sharing of knowledge. Yeah, thank you.